Good morning, you're Judge Randall, and this is cause number 24 DCCR 0543, and Mr. Randall was previously in court, entered pleas of true and a motion to revoke probation, pled true to counts 1, 2, 4, 5, and 7 and 8 on probation for the first-degree felony offense of aggravated robbery. And I've received the pre-sentence report update. Have you all had an opportunity to review that?
We have, Your Honor.
I have, Your Honor.
Are there any additions or corrections?
No, Your Honor.
Well, Judge, I noted probation's opinion that continuing on probation may not be a good idea. And I know we'd agreed on ISF and an attempt to keep him from being revoked. I understand if the court feels differently.
I didn't know that that was an agreement, and if it was, I show that you are asking for that, but I didn't think
And
the state.
I think what I stated was I wanted to see the PSI
Yeah,
and get an idea of what has
The
really
new-
happened or not happened on probation.
well, he pled true, on probation for a case, an aggravated robbery that involved shooting out the window of a car at someone after having stolen stuff from that person. New offense, pled true to being arrested for unlawful carrying a weapon and evading arrest or detention. So, I'm not inclined based on, you make argument, Mr. Rojas?
Yeah, Judge, and my understanding was that it wasn't agreement for ISF, but and if it wasn't, then obviously the court can do whatever the court feels is appropriate.
Can you look, pull up that paperwork? What was the date of, it's not finalized, so the plea paperwork should still be somewhere on the tablet.
26.
If you can get 826 pulled up, do you know how to do that? And send it to me, send his paperwork to me, please. And if that's what y'all's understanding and you need some time to prepare for a hearing, I can reset it for a couple of weeks, if you want to do that as well. But let's see what the paperwork said first.
I think we discussed it, and I said I want to wait and see what PSI says. Let's double check.
Okay.
It is marked off on an agreed punishment recommendation, ISF cognitive, but it doesn't say wait or anything like
Okay.
that, but I don't know that I'm inclined to do that. What is the status of, are those cases down in misdemeanor court?
They're still pending, Judge. He's been appointed, Mr. Cole, to be his attorney, and I talked with him about the issue that he's inclined to go down and plead those cases once this is all taken care of.
I would like to know, at least see a PC on that new arrest.
I
If you
right
have
here,
it, you do?
Yes, Your Honor.
Any objection to me?
No objection.
reviewing that? On probation for an aggravated robbery. And if I recall, I don't know that it was ever on, when I tried to go back and see, nobody really said or could tell for sure who shot out of that car that night. But if I'm correct, I feel like Mr. Randall, who was in the back right passenger, was potentially, it was out of the back.
Judge, I feel like because I remember this case, there was four individuals in the car.
Did
I
anyone?
don't think I would have lowered his to a non-aggravated if I had believed that he was the shooter in that case.
They did gun residue, Judge, and there was no gun residue on Mr. Randall's hands.
Because it is a non-aggravated robbery, is what it is,
Okay,
what he's on probation for.
but
He was in the
still
car.
in, I mean, still in out of other, breaking into vehicles and,
Multiple vehicles.
yeah. And then here we are, May 3rd, so less than a year after being placed on probation, riding around, smoking pot with a gun, and when you got taken out of the car, ran from the cops. No. Go ahead, you can make argument.
Judge, my intention was to come in and ask to follow the agreement for ISF. It doesn't appear that the court's willing to do that. I would point out that this is an offense that happened when Mr. Randall was a relatively young man. He's still a young man. He is the father of a young child. I think he's a 3-year-old. 9-month-old child at home, Judge. He is obviously making some bad decisions in his life, going all the way back to the original offense date. And that was why I thought ISF would be maybe helpful to him, to give him some information to help him redirect his life, make better decisions in his life for himself and for his daughter. He's a pleasant young man. Every time I go talk to him, he's a really nice, pleasant to deal with. He's never had any blow-ups here in court that I can recall. He's had maybe some jail incidents. I think he threw some soap around one time and some wardrobe incidents. But other than that, I think he's been well behaved in jail. I would ask the court that if ISF is not going to be possible in this case, that you consider doing something towards the lower end of the punishment range. I don't know that. And again, Judge, I think that's why I think ISF would be better for him. We can send him to prison right now for whatever amount of time, but if he doesn't get the help and the education that he needs, he's going to come out and be the same way, even worse. So,
Judge, I'm sorry to cut you off, Mr. Ross. I'm showing that 2 new cases were received last week by my office concerning the exact same UCW and evading from July 13th, which is not alleged in the motion. If we need to amend to add those, or if you want to address those.
Another arrest?
That's what I'm showing, Your Honor. Two more pending, not yet filed misdemeanors for evading.
This is May 3rd.
Yeah, a different offense date. So if we want to take some time so I don't have the probable
Absolutely.
cause available to me,
Yes.
but I can get that, obviously. If we can take a week or so to file an amendment.
Let's go ahead. I'll probably, just based on, court schedule, I'm going to, I want that back.
Yes, Your
I'll,
Honor.
let's reset it about 3 weeks. And if there is in fact a new arrest, I would like that.
Certainly.
In the
What I'll
motion.
do is file an amendment to reflect any new offenses or charges, Judge.
Yeah, that'll change everything potentially. So yeah, let's see where we get with that. Go back with the bailiff. You probably need to talk to hey, Mr. Randall, also, you need to talk to Mr. Rojas. You need to tell him everything that's going on. He doesn't need to be surprised here in court. If you've been arrested again for something, y'all should be talking about that.
Thank you, Your Honor.
Thank you, Mr. Nichols.
Mr. Wilkerson.
Oh. All right, ma'am, are you Toy Hill? And Ms. Hill, you were previously in court, entered a plea of guilty to assault family violence by impeding breath or circulation. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
State has to.
Are there any additions or corrections?
Not from the defense, Your Honor.
Not from the state, Your Honor.
My inclination, if I'm going to follow this agreement, is possibly based on some of the statements of family members as well as probation, is special needs safety. There's obviously some drug, thank you so much. There's obviously some drug history and abuse of several different things in that list, as well as some mental health issues that need to be taken care of. And I think to get started on this probation, if I'm inclined to go along with it, that's what I would be inclined to do. Do you want to?
Yeah, I got good a minute.
Yeah, visit with her about that, but that's based on the history, with same types of offenses. That's where I'm headed. So y'all can visit for a minute and then I'll take care of it, just so she knows what I'm talking about. Good morning, sir. You're Larry Fitzgerald Williams. And in cause number 25, DCCR 0985, Mr. Williams charged with capital murder. And then the other case is a motion to revoke probation that Mr. Johns represents him on in cause number 24, DCCR 1790. It's not a motion to revoke probation. I'm sorry. The other case is an aggravated assault causing serious bodily injury. And so, Mr. Cashin, obviously your case is the top one on that. What is your announcement?
We are not ready to proceed yet. We need to get all the information from the DA's office. We have to review some of the evidence that they have provided. We want some phone records. I'm going to get with ADA about some of the phone records, the forensics on his cell phone, the forensics on the phone of the decedent, and a couple other things that we have to do.
And do you have everything in your possession to turn over at this time that you know of, Mr. Smith?
As far as I know, Judge, we do.
Okay. If y'all will just get together and visit about that, if there's something that Mr. Cashin needs that you don't have, if you'll get with law enforcement, let's get everything. And then what I'm inclined to do, just based on upcoming holidays and things like that and resets, I'm inclined to give a longer reset, but I don't want y'all to wait till the last minute. If I do that, go ahead and get everything, visit. I'm going to do a reset to maybe that first week in January. That should give y'all plenty of time, hopefully on a case of this nature, to get more up to speed. And then I'd like an announcement if we can on that date.
That's kind of what I was expecting.
Okay, sounds good. Then we'll see you back then. Thank you, sir. You're free to go. You can go back with the bailiff, sir.
Yes, Judge.
And Ms. Hill, in cause number 25, DCCR 0650, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of assault family violence by impeding breath or circulation. Sentence you in accordance with your agreement to a term of 10 years in prison, but I'm going to probate that. You'll be on probation for 10 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. One of those conditions is going to be that you enter and successfully complete this special needs safety program. That is intended to help you with everything that's going on in your life, any mental health treatment you need, as well as substance abuse treatment, so that when you get out, you'll be better equipped to be successful on this probation. And so if you do everything that you're supposed to on this probation, then for all practical purposes, your case here in court is over, and you'll be able to serve that 10-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you can be brought back in here and you'll be looking at that 10-year sentence that you've already agreed to. Do you understand? Also, it's very important that you understand you can have no contact or communication with Cheryl Johnson. That's in person, that is electronically, through messages or anything like that. Do you understand? And even if she gives you permission and says, oh, it's okay, I'm not giving you permission, and that's how that has to work. You understand? All right, so I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your rights to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. And so Mr. Hancock is charged in 25 DCCR 0737 with evading arrest or detention with previous convictions. Cause number 25 DCCR 0738 with continuous violence against the family. And then there's a third case. Those both have offense dates of April, well, the first one is April 22nd of 2025. The second one is April 26th of 2025. And then in cause number 25, DCCR 1233, there's a new evading arrest or detention with previous convictions from August 5th of 2025 that has now been indicted. And Ms. Holmes has filed motions in the first two cases asking that I reduce Mr. Hancock's bonds, which are currently set at $100,000. It looks like there was a court date on July 22nd of 2025 that Mr. Hancock missed, and so that was when those bonds were increased.
On July 22nd?
Mm-hmm.
Okay.
And then, so he missed court on that date. So there it was, before that, there was an AFRS that was filed by the bondsman to get off the bond. But when he didn't show up, the bond forfeiture overrides that. And so that was the bond forfeiture. And then also, since then, there was a request for an emergency protective order. Oh, that was just filed in the case. Okay, it looks like that was from back in the arrest on, where's the date? April 26th. Okay, so I'm also reviewing jail incident reports that I have received. Have you had an opportunity to review those? Yeah. Why don't you take a look at those, and then before you try to make arguments on behalf of your client who's making things very difficult for you, y'all can go review those, and then we'll come back and discuss
Judge,
the
I think if you
bond.
just let me review his criminal history, the stage will be very easy.
I've already know what I'm gonna do, but I'd be glad for you to do that as well.
Your Honor,
Okay.
he's habitual on this continuing violence against the family case. He has a total of, I believe, 10 prior felonies. And on these two evadings, the state jail evadings with prior evading convictions, he has a total of 7 evadings. And the most recent one was picked up when he was arrested in August while he had warrants for these pending cases. His priors that are not evadings include firearms, drugs, and burglary.
Okay. Ms. Holmes?
He had only been off of parole about 2 months before the new offense date in April.
What is that? Let me look at something else that's new. I want to see what the bond is set at on the new case 25 DCCR 1233. Because honestly, based on everything I'm seeing, I'm not sure the bonds are satisfactory. We'll see. So Ms. Holmes, any
So, Your Honor, I was provided some documentation. Apparently, Mr. Hancock did go to the hospital in July, which I believe at the time he did provide that documentation to the bondsman. I'm not sure if he was aware that an AFRS had been filed at that point. He is aware that he needs to behave in the jail.
really, you're aware of that? How old are you?
I'm 36.
You're 36 years old, so you needed to come here today and have her tell you you need to behave in jail?
No, man.
This is ridiculous. These people are just going to work and trying to do their job. That's all.
Yeah, man.
You know, I mean, that's what the rest of us do. We go to work, we do our job, we go home, we live our lives, and we don't have punks like you acting like this and treating us this way when we're at our job. The way you have spoken to The officers, the female, they disrespect you first. You think you earned their respect? You're in jail. You follow the rules. Their job's just to do their job. If it's time, you don't get to make decisions in jail. You don't get to decide when you turn the lights on and off. You don't get to decide when you go to bed or when you eat. It's not your decision anymore. That's what happens when you continue to violate the law. You've lost your right to make those decisions. So it's their decision to try to keep everybody in order out in the jail the best they can. And the way you have spoken to them and threatened them is actually a violation of the law, and you could end up with more cases for threatening a correctional officer. So just keep going, keep stacking it up. I'm sure a jury later will love to hear all of that. They'll love to hear it. You're looking at 25 to life on one of your cases. Keep it up. Let's see what happens. Because a jury will see all of this. And if you think I'm going to take some great deal that they're going to negotiate, or you think Mr. Nichols is going to give you some great deal, it's not happening. So you're old enough to know better. I'm going to deny the motions for a bond reduction in cause numbers 25 DCCR 0737 and 0738 based on several factors: your criminal history, the fact that you did miss court, the fact that your bondsman had already filed an AFRS, your jail incident reports. I am also going to find in cause number 25 DCCR 1233 that your bond is insufficient. And in that case, I'm going to raise your bond to $100,000. A condition of all of these bonds, if you make them, will be that you will be required to wear a GPS monitoring device, and you will be on house arrest. So if you make these 3 bonds, you will be on house arrest. You're not allowed to leave your house unless you have my permission. And you will be also ordered, and it should already be in a bond condition in cause number 25 DCCR 0738, to have absolutely no contact, no communication at all with the complaining witness. Do you have that name handy?
I do, Your Honor.
Janaisha Butler.
Janaisha Butler?
Jamaisha.
Jamasha.
So you cannot have any contact whatsoever with that person. Do you understand? That also includes when you're in jail. So there's no sending messages through that email system or anything like that to her through anybody else. That'll be a violation of your bond, and your bonds will end up raised even more. You understand? All right, I'll reset it for a sentencing, for an announcement. We'll deal with all of the cases at that time.
Thank you, Your Honor.
Thank you. Would you please raise your right hand, ma'am? Do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English?
Yes, Judge.
Thank you. Sir, are you Wilmer Godinez?
Yes.
And will your client waive the formal reading of the indictment?
Yes, Your Honor. There you go, Judge.
Mr. Godinez, in cause number 24, DCCR 2040, you're charged with the second-degree felony of aggravated assault with a deadly weapon from August 29th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they charged you with?
Yes.
I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Wilkerson?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
I understand.
Also, do you understand, if you're not a United States citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law.
I understand.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Godinez is not competent?
No, Your Honor.
Mr. Godinez, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 12 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative finding of a deadly weapon. I'm going to hand you the trial court certification. This shows that this was an agreement that I followed, and so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. That's in Spanish, so you should read it carefully. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or how long that lasts, you can talk with Mr. Wilkerson. Yes, sir?
We've included in that plea paperwork that the sentence in this case run consecutive to the federal sentence. I know you don't necessarily have any control over that. The only reason why we included it is because Judge Crone on the federal side ordered it.
Okay,
So
so consecutive.
consecutive.
And so, Mr. Godinez, I want to make sure you understand that this sentence will run consecutively with any federal sentence that you're serving. Do you understand?
Yes.
All right, thank you. You can go back with the bailiff.
Thank you, Your Honor.
Thank you, Ms. Burge. Dalvius Williams. Good morning, sir. You're Dalvius Williams. And Mr. Williams is charged with injury to a child, elderly, or disabled individual in cause number 25 DCCR 0176. And what is the announcement?
Your Honor, if we could get just one more reset on this case. My client wasn't aware, because the priors aren't listed in his indictment, that the state would move for or give a notice of intent on extraneous offenses if this goes on to trial, increasing the punishment range. His admonishment, because I assume they weren't in the indictment when he did a plea rejection, was for 2 to 10 rather than 2 to 20.
Okay.
So I believe the state would stipulate he has 1 8-year sentence in TDC and 1 state jail conviction.
Okay, and I don't see that that's been filed yet, but I will give you some time if you want to go ahead and get that filed so it's on the record, and then we will reset it. And so, Mr. Williams, you can go over with Mr. Wilkerson what the possible consequences are if you go to trial based on any criminal history and what your options are, and we'll get an announcement at the next court date. All right, you can go back with the bailiff. Good morning. You're Wynn. And Mr. Wynn, you were previously in court in cause number 25 DCCR 0750 and entered a plea of guilty to burglary of a habitation. I've received that pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Yes, sir.
Are there any additions or corrections?
No, just a request.
Ms. Holmes?
Yes, Your Honor, after I reviewed the PSI with Mr. Nguyen, we do see that the probation's recommendation is for him to enter and complete the cognitive track of ISF. Mr. Nguyen did ask me to recommend if possibly the court could hold it in advance. He does have a plan to enter into a residential treatment program called South Point upon release for probation, so that he can stay on top of or to maintain some sobriety, because I believe that's the root of a lot of what's going on with involving him with his family and past history. And so we were requesting if the court could consider holding the cognitive track of ISF in abeyance and allow him to enter into that residential treatment program.
So here's what I'm more inclined to do, is I'm going to order the substance abuse track of ISF instead of the cognitive, if that's the main issue, and there's, I would rather that be that intensive inpatient in custody treatment, and then when he gets out, if there is a treatment that probation will approve for aftercare, that's fine. Otherwise, he'll do the aftercare that's part of this, but you can talk to probation about that. But with this history, with what's been going on, and the fact that you continue to do this to your mom is what is very concerning. Sounds like she is pretty fed up, and probably for very good reason. So anything else?
No, Your Honor.
Okay, so what I'm going to do then, Mr. Nguyen, is I'm going to follow the agreement that you made with the district attorney. I'm going to defer all proceedings, place you on probation for a period of 8 years. You're ordered to pay a $500 fine, and you're ordered to enter and successfully complete the substance abuse track of the ISF program. And then for aftercare, you will do whatever aftercare probation deems appropriate. If there's some other program that you want to still go to, you can talk to them about it, but it has to be approved by them and by me, all right? We want you to get the help you need, but I want it to be right now up front and in this program. When you're out, you will be on the high medium caseload, which means at first your probation is going to be you're showing up more, you're getting drug tested more, and following through with everything that you're supposed to on this probation. That also includes not having any contact with your mom. That's in person, that is through calling or texting or anything like that until further order of the court. Do you understand? If you do everything that you're supposed to, get your life on track, take advantage of this that you're getting today, then this is an excellent opportunity, because you do not have a felony conviction on your record. And at the end of the probation, you will actually, if you do it successfully, the case will be dismissed. You'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you'll be brought back into court. You could be found guilty of the offense, so you would become a convicted felon, and I could sentence you to prison for anywhere in the range of punishment, which is up to 20 years. Do you understand? Yes. All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I think that's any other, I was looking at the conditions to make sure there was nothing else. Obviously, you're also not to be anywhere around 5080 Helbig Road. So if you need to go somewhere, you go a different direction.
What is that address?
Is that not your mom's address?
I think that was that.
Oh, her employment potentially? I think that might be where she's employed. So talk to probation about that, but 5080 Helbig Road, you are not to go to, you're not to be anywhere where your mom is, all right? If you're somewhere and she's there, you're the one that has to leave. Make sense? All right, good luck to you, sir. You can go.
I did have some misdemeanors. Would I be able to take care of those before I go to the treatment?
You have to take care of them before you go. Actually, there's a whole, you won't be able to go. And so we'll let the misdemeanor court know that this case is over, and hopefully they can get you over there on a jail run this week, and you can get those taken care of, okay? All right, you can go back with the bailiff. Yeah, y'all look and see which one.
J. Rodri Randall stood before Judge Raquel West on a motion to revoke probation stemming from a first-degree felony aggravated robbery case. He had previously pleaded true to multiple violations, including new criminal conduct, unlawful carrying of a weapon, and evading arrest. At the outset, defense counsel believed there was an agreement for placement in an intensive sanction facility, ISF, as an alternative to revocation. However, Judge West immediately clarified that she had not committed to such an agreement and wanted to review the pre-sentence investigation, PSI, before making any final determination. The underlying case carries significant weight. Randall was originally placed on probation for an aggravated robbery involving stolen property and gunfire from a vehicle. While the charge was ultimately reduced to non-aggravated robbery, the court recalled serious concerns about the circumstances. Less than a year into probation, he was arrested again, this time allegedly riding with a firearm, smoking marijuana, and running from police. Defense counsel argued for rehabilitation over incarceration, emphasizing Randall's youth and his role as a father to a 9-month-old child. Counsel maintained that ISF treatment could redirect his life and prevent future criminal behavior. But the hearing took a critical turn when the prosecution revealed 2 additional pending misdemeanor cases for unlawful carrying of a weapon and evading arrest, separate from the violations already alleged. These new potential arrests were not yet included in the motion to revoke. That revelation changed the trajectory of the proceeding. Judge West declined to issue a final ruling and instead reset the case for 3 weeks, allowing the state to amend the motion if necessary. The judge explicitly stated that new arrests would change everything potentially. The legal stakes are enormous. Because Randall has already pleaded true to multiple violations, the court has full authority to revoke probation and impose a prison sentence within the statutory range for the underlying robbery offense. A revoked probation could mean years of incarceration. The postponement underscores a key principle in revocation hearings: transparency and accountability. The judge warned Randall directly. His attorney should never be surprised in court by new arrests. This case now sits at a crossroads. If the amended motion includes additional offenses, the possibility of no plea deal and immediate imprisonment becomes far more likely. The next hearing may determine whether this remains a treatment-focused outcome or becomes a final ruling sending him to prison.